Welcome to Heald Law Academy, the place to understand how to grow and protect your business. Today I'm with Caroline Wilton, who's the partner heading up the Commercial Property Department at Heald Solicitors LLP. And today we're going to find out about why heads of terms are so important to get right. Caroline, welcome. Heads of terms, why is it so important to get them right from the get-go?
The important thing about heads of terms is that they set the scene for the deal. They're not legally binding, but the more accurate they are, the more they set out what people are looking for, the less likely you're going to fall over once the detailed negotiations are taking place. If you don't follow the heads of terms, you're on the back foot all the time.
Right. So give us some examples of the consequences, perhaps.
A classic example that I've had very recently is the rent-free period that every sensible tenant tries to negotiate. The tenant said, oh yes, let's have a rent-free period, let's say from the start of January. Everybody's happy with that. Unfortunately, the lease ends up being delayed for various reasons. January comes and goes, and suddenly the landlord is saying, well, I calculated that my rent-free concession was going to be at the start of the year. I'm not going to give you any more. You've delayed. I don't care. This is when your rent starts. What the heads of terms should have said, for example, was you will get 2 months rent-free from the start of the lease. And it's this little type of detail that can be so important to both sides.
Okay, what about car parking and things like that?
Again, it's very easy to think, oh, you can have 6 car parking spaces. Quite often what that means, however, is, oh, you can have 6 car parking spaces in the general car park as long as nobody gets there first. The important thing is to say, actually, I would like 6 allocated car parking spaces just to me. And if you don't get that at that stage, it's going to be very difficult to argue. If you find that the landlord, for example, is saying, well, sorry, we can't do that, it's a first come, first served basis, then at least by knowing it at that stage, you are going in with your eyes open. If you have another place that you're looking at that has a comparable deal, but with car parking, that might tip the balance the other way.
Okay. Now, something that landlords and tenants always seem to be arguing about is the condition of the property. What about that there?
Right. A landlord will always want the tenant to be responsible for the repair. A sensible tenant will look at the condition of the property and negotiate accordingly. Unless the property is brand spanking new, every tenant should seriously consider having what's called a schedule of condition prepared so that they are not obliged to put the property back in any better state than it is at the time they took it over, because that's what they'll have calculated their rent on. If they don't do that, then they need to consider perhaps improving the rent-free period to actually help cross-subsidise the fact that they are going to be out of pocket doing repairs.
Is there any kind of grey area of wear and tear, general wear and tear, or, you know, I mean, if you're using a property for a long time, it's going to be in a different condition, surely? And
that is one of the reasons why it's very important to take legal advice to understand exactly what you're signing up to, because a standard lease will require the tenant to sometimes put it in a better condition than the tenant actually found it in.
Okay, let's talk about the break clause. Can you have one? Who has it?
Anybody can negotiate a break clause. They have been very common recently because the economy hasn't been so great and landlords have been using them as incentive to get a tenant in. The landlord's perspective will be, I want to make the break clause as difficult as possible so that the tenant won't leave. And of course the counter is the tenant will just think, well, I agreed I was going to give 6 months notice, that's all I need to do. The advantage of having detailed heads of terms for a break clause is to set out quite clearly what the tenant is expecting. If the tenant says 6 months notice and no other conditions, then it is very easy to put this to the landlord solicitor when they're drawing up the lease, and the landlord solicitor will not be able to sneak in all the other little hoops that one would normally expect to be put into a lease to make it more difficult for the tenant to exercise the break clause. But you have to be quite careful about putting them in the heads of terms, because otherwise they will just go on their standard clause.
Is there anything that the tenant can do to minimise risks of being caught up in something or getting stuck?
I would always advise tenants to run their heads of terms past their lawyers before they actually sign them up, because that way they can look out specifically for this type of issue, and perhaps throw in some other commercial points that the tenant would not necessarily have thought of, that the solicitor would know about because of local knowledge.
Okay, thanks very much, Caroline. Well, that's it for now. Now remember to subscribe for all of our videos, news and events, and feel free to use our website or social media to ask any of our experts any questions you may have about commercial law. Bye for now.